Hey everybody, Sean Bukowski here. Hope you're all having a great week and looking forward to Thursday with turkey and stuffing and mashed potatoes and friends and family and Detroit Lions football. What could be better than that? But before we do that, I want to talk about something that's kind of in the news here a little bit, and it's something we've dealt with similarly at the firm recently with some of our clients, or at least one of our clients. And that's, you probably saw Meta about 10, 11 months ago. I think I wrote about it. Sublease like 589,000 square feet in an office building downtown Austin. And that office building's not yet built, finished, I should say. Meta has not yet moved in, and already they've announced that they're not going to use all that space, and they're looking, I don't know how much they're going to use, but they're looking to sublease out a bunch of it. And so that's what I want to talk about, the difference between sublease and assumption and why it's so important for a landlord to know the difference and why it should be explicitly spelled out in the original lease. So first, sublease. Sublease is, okay, if your tenant doesn't want to use all the space, the party can bring in another party or a subtenant to lease up some of that space. But as the subtenant, their obligations and rent is due to the tenant, and the tenant then is obligated to the landlord. So if the landlord does not get rent from the tenant, its recourse is to go against the tenant. It doesn't matter if the subtenant pays or doesn't pay the tenant. That tenant is still responsible for the rent to the landlord. And then if the subtenant didn't pay the tenant could go after the subtenant, but it's still obligated to pay rent to the landlord. Contrast that with an assumption where the new tenant basically steps into the shoes of the original tenant. And so it takes over all the obligations and rights under the original lease, and is basically a completely new tenant. The original tenant is released from the original lease entirely, and no longer has any rights under the lease or obligations to the landlord. So if the landlord doesn't get the rent, its recourse is against the new tenant, not the original tenant. And it's so important to have this really spelled out in the original lease. You need to make sure that your lease covers both subleases and assumptions. And basically, with our clients, we say, okay, you can allow it, but only if expressly approved in writing by the landlord. And the landlord can withhold that approval, because what you don't want is your tenant saying, I don't want this space anymore. I'll bring in Joe Schmo over here and he'll step into my shoes and then he'll pay your rent. Well, that's not any good for the landlord, because you have no idea if Joe Schmo is going to be able to pay the rent, is qualified, whatever. So the landlord, we really recommend our clients make sure in the original lease, the landlord has the power to veto, to say no to any assumption or sublease, to make sure its rights are protected under that lease. Hope you enjoyed this. Hope you have a great Thanksgiving. And please sign up and subscribe to our blog, our YouTube channel, and our podcast. Have a good one.